Welcome to the lecture on admissions and confessions under the Indian Evidence Act 1872 and the Code of Criminal Procedure 1973, along with the latest developments by M.P. Siddhesh. This is part 1 of the lecture. In this lecture, we shall have the following learning objectives. Number 1, we shall become familiar with the basic concepts of admissions and confessions. Number 2, we shall understand the important elements of admissions and confessions under the Indian Evidence Act 1872. And finally, we shall take a look at how admissions and confessions come into play in a criminal proceeding under the Code of Criminal Procedure 1973. We shall be covering the following subtopics in this lecture. First, we will become familiar with the basic ideas behind admissions and confessions. Next, we shall look at some of the important features of admissions under the Indian Evidence Act 1872. Next, we shall deal with the essential elements of confessions under the Indian Evidence Act 1872. And finally, in this part, we shall become familiar with the interplay or the interaction between the Evidence Act and the Code of Criminal Procedure. We shall deal with the following subtopics in the next part, that is, part 2 of this lecture, which will be uploaded on Tuesday. They are the treatment of admissions and confessions under the Code of Criminal Procedure, important cases pertaining to the topic of admissions and confessions, and finally, we will undertake a comparative analysis between the Evidence Act and the CRPC on one side and the latest Bharatiya Sakshya Bill and the Bharatiya Nagarik Suraksha Samhita Bill on the other. Let us start this lecture with the subtopic of admissions. So what are admissions? Admissions are defined under section 17 of the Indian Evidence Act 1872. Now, I recommend you to pause this video for 2 minutes and read the definition which has been given in this slide. From this definition, we can understand that when a person says something or states something that is contrary or against his own interests, it can be said that he has made an admission. Let us turn to some of the important features of admissions. The thumb rule is that admissions must be self-harming. This means that an admission must always be against the interest of the maker. What is the rationale behind this rule? This rule is based on a postulate that a person does not make self-harming statements unless they are true. Therefore, generally, self-serving statements are not admissions. However, there is an exception to this rule in the form of Section 21 of the Evidence Act. Section 21 defines the circumstances in which self-serving admissions can be proved in favor of the maker. We shall deal with the fine points and intricacies of Section 21 in the next part or part 2 of this lecture. Next, please remember that admissions under Section 17 to 21 of the Evidence Act must be oral or in writing. It does not cover admissions by conduct. Section 8 of the Indian Evidence Act deals with conduct which might or might not amount to admission. Most importantly, admissions are an exception to the rule against hearsay. Hearsay, as you might recall, is second-hand information which is generally not admissible as evidence. However, there are 3 exceptions to the rule against hearsay. They are res gestae evidence, number 2, admissions and confessions, and number 3, situations where the maker of the statement is dead, missing, or is unable to come to court due to disability. Therefore, admissions are an exception to the rule against hearsay. Now we shall try and understand the role of admissions in the whole structure of the Evidence Act. Where do admissions fit in? What are the similarities between admissions, confessions, and statements? Well, according to the Honorable Supreme Court, statement is genus, admissions are the species, and confessions is the subspecies. Let us try and understand that statement with the help of a Venn diagram. As you can see, all admissions and confessions are statements. Further, all confessions are admissions. But on the other hand, not all admissions are confessions and not all statements are admissions or confessions. Please note that sections 17 to 21 of the Evidence Act deal with evidentiary admissions. This means that admissions under section 17 to 21 must be proved in the court like any other evidence. There is no presumption of truth in case of evidentiary admissions. Evidentiary admissions may be disproved by the maker. On the other hand, Section 58 of the Evidence Act deals with formal admissions. Formal admissions are admissions where no proof is necessary. It constitutes a waiver of proof and the court assumes them to be true or there is a presumption in favor of the admission being true. Let us turn to Section 21 of the Evidence Act. Section 21 states that admissions as defined under Section 17 to Section 20 are relevant and may be proved against the maker. There are a few exceptional situations where admissions may be proved in favor of the maker. As per Section 21, these situations include: number 1, the maker of the admission is dead and his admission is relevant as per Section 32 of the Indian Evidence Act. Number 2, the admission pertains to the existence of a state of mind or body which is relevant or is an issue when such a state of mind or body is accompanied by conduct which suggests that the admission is true. And finally, number 3, when the admission is relevant otherwise than as an admission. I perfectly understand that this is very difficult to understand in the abstract. Therefore, we shall look at some of the illustrative examples in order to understand what all of these conditions actually mean. Let us deal with subsection 1 of section 21. According to section 21, subsection 1, an admission may be proved in favor of a person if it would be relevant as per section 32 of the Evidence Act 1872. Section 32 defines the situations in which statement of a dead or a missing person is admissible. Therefore, from a combined reading of sections 21 and 32, we can say that admissions may be proved in favor of a person making them if the admission would be admissible if the person were dead or missing. Now we shall turn to subsection 2 of section 21. We shall try to understand this subsection with the help of an illustrative example. Imagine that A was running in the direction of B. B observed that A had blood stains on his shirt and there were a few wounds on his body which were bleeding and that he was out of breath. B told A that C tried to kill me by stabbing me with a knife. In this situation, the state of mind or body is the bleeding and the existence of wounds. And the accompanying conduct which accompanies the state of mind or the body is A running in the direction of B. Therefore, the admission made by A that C tried to kill him by stabbing him with a knife will be admissible in a court because it describes the state of mind and body accompanied by the conduct of A, which makes it highly unlikely that A is telling a falsehood. So, the $1,000,000 question is, what is the value of an admission for the prosecution? What is the evidentiary value of admissions? How much weight does the Evidence Act attach to admissions? It must be remembered that admissions, if true and clear, are a strong and almost conclusive evidence against the maker. However, as per Section 31 of the Evidence Act, they are not conclusive proof of the matters admitted. Like we saw previously, this means that there is no presumption of truth in case of evidentiary admissions and they must be proved in court.
Now let us start with the subtopic of confessions. Confessions have not been defined anywhere in the Code of Criminal Procedure or the Indian Evidence Act 1872. However, James Fitzjames Stephen, who was the author of the Indian Evidence Act, has defined confessions in his book Stephen's Digest in Criminal Context. So please take 2 moments and pause this video to read the definition which has been reproduced in this slide. So, according to this definition, a confession is an admission of an offense or an admission of all the facts constituting an offense.
Now, let us familiarize ourselves with the important features of confessions. The thumb rule in case of confessions is that confessions cannot contain self-exculpatory statements. The reason behind the existence of this rule is very obvious. Confessions, by their very definition, means admission of an offense. So, how can a statement which contains self-exculpatory statements be a confession at all? It cannot be. Therefore, such statements are thrown out and are ignored in totality. Now let us deal with Section 24 of the Evidence Act 1872. According to Section 24, confession of an accused is irrelevant in a criminal proceeding if it appears to the court to have been caused by any inducement, threat, or promise having reference to the charge against the accused. Number 2, the threat, inducement, or promise proceeded from a person in authority, and the threat, the inducement, and the promise are sufficient in the opinion of the court to give the accused grounds which would appear to him reasonable for supposing that by making it, that is, the confession, he would gain an advantage or avoid an evil of a temporal nature in reference to the proceeding against him. We shall discuss the subsections of Section 24 in detail in the next few slides. So, what is included in the words inducement, threat, or promise? Please remember that in practice, the accused may be faced with both a combination of threats and promises. Certain things like mere threat of a police complaint and things like religious absolution do not constitute a threat or a promise or an inducement. What is meant by the expression a person in authority? A person in authority does not necessarily mean the police. According to the Honorable Supreme Court, it may be anyone involved in arrest, detention, examination, or prosecution of the accused. In my personal opinion, a person in authority includes all the state functionaries under the Code of Criminal Procedure who are involved in the administration of the criminal justice system. And finally, in order to determine whether the confession was the result of a threat or promise, the court must put itself in the shoes of the accused and then determine the effect the inducement might have had on the mind of the accused. This means that the court must conduct a subjective exercise and determine the answer to the question with reference to the specific facts and circumstances of a case. Let us discuss some of the important elements of confessions under the Indian Evidence Act. According to Section 25, no confession made out to a police officer is relevant or shall be proved against the person accused of an offense. What is the objective behind this rule? Very simply, it is based on the postulate or the assumption that there is no way to make sure whether the confession made to the police was voluntary or not. This is because, in practice, the police may have extorted such a confession from the accused simply to secure an overall high conviction rate. Now, let us take a look at Section 26. According to Section 26, no confession made by any person in the custody of a police officer shall be proved against him except if the confession is made in the presence of a magistrate. Please remember that custody does not necessarily mean formal custody. The person need not actually be in a jail or a lockup. It has been held by the Supreme Court that a person is in custody when there exists some form of surveillance or a restriction on his movements. The underlying principle behind this section is that custody renders a confession involuntary. In the next few slides, we shall become familiar with the Section 27 of the Indian Evidence Act. According to Section 27, when any fact is discovered as a result of information obtained from a person accused of any offense, that part of the information received which directly relates to the facts discovered may be proved against that person whether the information amounts to confession or not. What is the rationale or the objective behind inclusion of this section in the Evidence Act? First, please remember why confessions in certain cases are excluded. It is because of the risk of a false and involuntary confession coming on record. However, when some fact is discovered as a result of information obtained in a confession, the confession is naturally corroborated and is held to be true. This is also known as the doctrine of confirmation by subsequent facts. Let us try to understand what actually happens when Section 27 comes into play. We shall take the help of an illustrative example. So imagine that K, who was a co-accused in a murder case, informed the police that I ran for 5 kilometers, exchanged clothes and buried the knife below the banyan tree and then returned to the village the following day. Therefore, the concerned police officer may only depose before the court that a knife was discovered buried below the banyan tree as a result of the information obtained from K. The rest of the statement is not admissible. Let us try and understand the doctrine of confirmation by subsequent facts. The doctrine of confirmation by subsequent facts was first laid down by the English courts in Warwickshall's case. It is very interesting to note that this was a case that was decided way back in 1783. The doctrine which was laid down by the English courts in this case is still relevant today. That says something about the foresight of the English courts. So, the doctrine of confirmation by subsequent facts has been embodied in Section 27 of the Indian Evidence Act. The question of the applicability and the scope of Section 27 has been dealt with by the apex court in several cases like Himachal Pradesh administration and Om Prakash and the famous Parliament attack case of 2005. Therefore, the present position with respect to Section 27 is that the term any fact discovered includes any concealed object, the location of that object, and the knowledge of the accused which led to the discovery. However, for now, let us remember that mere intangible information without discovery of any concrete evidence is not covered by Section 27 and hence may not be proved against the maker of the statement. We shall be dealing with Section 27 again when we deal with the relevant provisions in the CRPC in part 2 of this lecture. And with that, we have arrived at the final subtopic of this part, that is, the interplay between the Evidence Act and the Code of Criminal Procedure. In the next few slides, we will try and understand this interplay. So, first things first, the Evidence Act is considered to be substantive law, and on the other hand, the Code of Criminal Procedure is a procedural law. The Indian Evidence Act defines what evidence is, when it is relevant, and what type of evidence may or may not be produced or tendered before a court. Meanwhile, the Code of Criminal Procedure, among other things, lays down the procedure for recording of evidence. It defines by whom such evidence may or may not be recorded, and also prescribes consequences for non-compliance with the procedures laid down therein. Please note that the Evidence Act and the Code of Criminal Procedure cannot be read and applied in isolation. Several sections of both the acts must be applied and interpreted together. Now, in the last slide of this lecture, let us take a brief look at some of the relevant sections of the CRPC dealing with admissions and confessions. So, some of the relevant sections of the Code of Criminal Procedure are: number 1, Section 162, which deals with statements made to the police and their use in a criminal proceeding. Number 2, Section 163 provides that no police officer shall offer any inducement to the accused as mentioned and like we previously discussed in Section 24 of the Evidence Act. And number 3, Section 164, which deals with the recording of confessions by a magistrate. We shall be dealing with these sections in detail in the upcoming part 2 of this lecture. We shall also undertake a comparative analysis with the latest bills known as the Bharatiya Saksha Samhita and the Bharatiya Nagrik Suraksha Samhita, which are going to replace the Evidence Act and the CRPC very, very soon. Thank you for watching. You can also watch part 2 of this lecture for a complete understanding of this topic. If you like the content, like this video and subscribe to this channel. You can follow this channel for new revision videos every week on Tuesdays and Saturdays. Thank you once again.